So it's now time to introduce Lexi Stangl. She's counsel to the Minnesota Senate, and she's also an officer for NCSL's Redistricting and Election Standing Committee. That means that we get to work with her on a pretty regular basis, and it's always a pleasure. Ben mentioned early in his presentation that there are state criteria, and now Lexi will give us some more details on that. And with Lexi, all yours.
Wonderful. Thank you, Wendy. I'm really excited to be here, be in Minnesota with all of you in New York. It's a lovely day here, and I hope it is there as well. I'm really excited to be here today to talk to you about redistricting principles. Although all of redistricting is really fascinating, this is one of the things I think is sort of extra fascinating. So I'm pleased that I'm able to talk to you about that today. As Wendy said, I should introduce myself again. I'm Lexi Stangl. I am with the Nonpartisan Office of Senate Counsel Research and Fiscal Analysis for the Minnesota Senate. And among other things, I deal with redistricting. So let's get rolling. So redistricting principles, a little bit about terminology. People call them different things. I tend to call them principles or criteria. They also can be called guidelines, standards, requirements. I'm sure there's lots of other names as well, but they're all the same concept regardless of what you call them. And what they are the ideas and concepts that are going to guide people, the map drawers, when they're making redistricting decisions. And as one of the earlier speakers mentioned, we sort of divide these into traditional and emerging principles. And we'll get into that in a minute and what that means. And a little bit more about what I'm going to be talking about today. So I'm just sort of giving you a menu of options of redistricting principles that states use. These are going to vary from state to state. As you look, NCSL has some really wonderful tables to see what states use what criteria. So I'm not here to tell you today what you should and shouldn't use as principles, but just to give you the information to think about as you move forward. So where do these things come from? You've already heard about the federal requirements from Senator Rosenberg, so I won't touch on those again. The main difference, I think, is those are requirements, and all states have to follow those federal requirements. But the principles really are more of the things that the states get to decide to use in addition to those federal requirements. So that's sort of the difference when we're talking about principles. So where do they come from? Lots of states have principles in their state constitutions, in state statutes. You might adopt them by resolution. It could be something that your commission has adopted. It could be a court order. Or in some situations, like in Minnesota, they can come from a variety of different places. So if you haven't already done so, it's a good idea to go back and look for any principles New York already has on the books and what was used in 2010. And as you're looking at that, it's important to understand and look to see if they were permanent or one-time principles. So what do I mean by that? So your permanent principles are the things like in your state constitution and state law that are ongoing and will not change unless you amend them. But in some states, if you do things, for example, by resolution, it might be a one-time adoption. So they applied in 2010, but will not necessarily apply in 2020 unless you adopt them again. And I understand that there's a fair amount of staff in the audience today. And just a little tip here. Members are going to like to know what you did last time in 2010 and probably 2000. Now is a good time to start putting together sort of a table of the past decade's principles, and then adding columns as you go forward if you have new bills or resolutions that propose different principles, so you can sort of track over time. I know the members here have really appreciated that. And then one final note that you sort of had an indicator of before, principles might be different for legislative and congressional maps. So we've seen some of these already. Senator Rosenberg and Ben did a great job sort of leading into this. So the first things I want to talk about are the traditional redistricting principles. And that phrase has been developed in the courts over the years about, what are traditional? What does that mean? It means they've been around a while. A lot of states use them, and they're considered to be important criteria. That doesn't mean you have to use these criteria. It's just a lot of states do. So the first three, contiguity, compactness, and preservation of political subdivisions, are all based on geography. And the Supreme Court has said that these are helpful principles because they're objective factors that used to defeat a claim of racial gerrymandering. So in other words, they're easy to measure and they're race neutral. The three remaining traditional principles are more based on policy objectives. So that means they tend to be a little more subjective and not necessarily as easy to measure. So moving on to talk a little bit about these in more detail. Compactness is the first criteria we'll talk about. So this means having the minimum distance between all parts of the district. So things like circles, squares, and hexagons are the most compact shapes. But of course, that's not really possible. You can't plop a grid down on the top of the state of New York and have nice, neat, square districts. That's just not a possibility. So what does it mean and how do you measure compactness? So the idea is to try to have regularly shaped districts when it makes sense. And how do you know if you achieve that? Well, there's the eyeball test. And courts have used that in the past to look at a district and say, yeah, that looks pretty good or not. And then there's also several ways to measure compactness that will give you a numerical score. And these are the things you might have heard tossed around, like REAC, convex hull, Polsby-Popper. There's probably a couple of dozen of these. And I think Moon is going to be with you this afternoon to talk about these. And she's incredible, so make sure you listen to her presentation. So context really matters when it comes to compactness. It sounds like an easy concept, but it gets complicated pretty quickly, especially when you start to get into looking at gerrymandering law and gerrymandering claims, which you're going to hear from other fantastic speakers, Michelle and Ben this afternoon. They'll talk to you about this. So context really matters. If you're looking at racial gerrymandering, it's really about the shape of the district. Is it a regularly shaped district? If you're looking at a voter dilution claim, it's about geographic compactness of the group of people whose vote is being diluted. And again, I won't go too far into that. We don't have a lot of time. Stay tuned for more this afternoon. I just really want to reiterate context matters, and the shape of your district may matter or it may not. Moving on to contiguity. So Senator Rosenberg touched on this a little bit earlier. Basically, this means all parts of the district are connected to the rest of the district. So you could get in a car or on a bike or whatever and get to every point of that district without leaving it. So there are a few tricky things to think about, or maybe not tricky, just things you want to think about ahead of time. The senator mentioned water contiguity. You'll see up there, there's a picture of Minnesota Senate District 65. And you'll see the river, that's the Mississippi River running right through the middle of it. And, it's not a lot of detail, but you can see that there are lots of roads and bridges getting over that river, which makes it easy to get back and forth. And water doesn't pose too much of a barrier to convenient travel throughout the district, so that seems to be acceptable. States and courts have looked at things like roads, bridges, and ferries to make sure that you can cross a body of water without it being too much of an obstacle. And if that is the case, if you can travel it easily, it's probably acceptable to have contiguity by water. So the other picture is a picture of the city of Rochester in Minnesota. And there are a couple of unique things here. So you see that arrow there, that's an example of point contiguity. What that means is the district only touches by a single point or a corner like that. And it's a good idea to think about whether point contiguity is sufficient or not. And then you'll see there's a circle there with a few little pieces of the city. Due to annexation over time, the city has ended up with pieces of the city that are not contiguous to the rest of the city. So to think about what would you do in that situation, particularly as we're talking about the next criteria where you're trying to keep cities together. The solution in Minnesota here in the last district, all of this was in the same district, so it wasn't an issue. But it's things like this that could be an issue to think about. One last note on compactness and contiguity. Often they're packaged together, and the requirement is compact contiguous districts, which makes it sound like they're one thing. They're actually separate criteria, and as you now know, they mean different things. So let's talk about preserving political subdivisions. This is trying to keep political subdivisions together as much as possible. Of course, especially in your large metro areas, that's not going to be possible. So in that case, split them only when necessary. So think about what are the political subdivisions you want to preserve. Usually it's things like cities, counties, towns, maybe election precincts, but you have other special precincts, school districts, watersheds, those kinds of things. And if you do want to preserve those political subdivisions, can you put them on a map? Make sure you have the data so you can put it on a map and make sure you are trying to preserve them. And the things you want to think about here to measure how well you're doing with this criteria is how many subdivisions are split and how many times are they split. Preserving communities of interest is exactly what it sounds like. This is where you're trying to keep geographical areas like neighborhoods or regions of your state together when the residents have a common interest that don't coincide with, city or county boundaries. So common examples include economic interest, social interest, school districts, community, housing, those sorts of things, trying to keep those groups together. Now, the Supreme Court hasn't given us a lot of guidance on communities of interest, but the bottom line is if communities of interest are used as a proxy for race, you need to follow the Voting Rights Act. So you can't get around racial gerrymandering requirements by saying it's a community of interest. So there's some interesting overlap there. The courts have also indicated that if you want to preserve communities of interest, it's a good idea to define and consider those before instead of using them as a justification after adoption. So what does that mean? Decide ahead of time what your communities are, try to define them, figure out how you're going to put them on a map, and have the data support that. Preserving cores of prior districts, Senator Rosenberg talked about this, and essentially it's trying to keep the district as similar as it was to what it was before. So in practice, what this means is starting with your existing map and sort of working around the edges as opposed to throwing the whole thing out the window and starting from scratch. One thing to think about here is what does it mean when you talk about the core of a district? Does it mean the population or the geography? So for example, you have a district that has a city in the southeast corner that's heavily populated, but the rest of the district isn't so heavily populated. When you say core, do you mean that population core of the city, or do you mean the actual geography of the whole district? So that's something else to think about as you're implementing this criteria. And finally, for the traditional principles is avoid pairing incumbents. And the senator spoke about this as well. So does it matter what party the people belong to? Does it matter if the person is not running again? I don't have answers for these questions, but they're things to think about. And oftentimes, you'll see this as a subordinate criteria. And what that means is it's sort of at the bottom of the heap when you're trying to comply with all of the other things. And that comes from a U.S. Supreme Court that said this criteria is inherently more political, which makes it more subjective and more difficult to measure, so it should likely be a subordinate criteria. And just if you're going to use this criteria, make sure you have incumbent addresses in the system so you can measure that. Emerging principles. So these are the newer criteria that have been considered and adopted over recent decades. They have not yet been recognized by the courts as traditional, but legally speaking, that doesn't make them any better or worse. It just means that they're a little bit newer. So the first thing to talk about is the prohibition on favoring or disfavoring incumbents, candidates, or parties. And Ben talked about this a little bit. So it's important to think about who is going to be included. And Ben did a good job summarizing that, so I won't go over it again. But what level of favoring or disfavoring? Is it any favoring or disfavoring? Or do you want to use the standard that a lot of states do and say intentional or unduly favoring or disfavoring? And again, this is often a subordinate criteria. The next one is a prohibition on use of partisan or political data. Here, the map drawers are prohibited from accessing and using that kind of data when they do their map drawing. If you want to do this, it's important to think about what kind of data do you mean? Do you mean incumbent addresses, election results, party registration, something else? And as you're thinking about this, are there any situations where any of that data may be necessary to comply with your other criteria, and how does that all fit together? Competitiveness, I think we've already mentioned it briefly, and this is the idea where you're trying to create competitive districts wherever possible and avoid drawing safe districts. And of course, we all know this isn't possible in some areas of our states. You just couldn't draw a reasonable district to do this. So oftentimes, this criteria will be followed by something, wherever possible, try to draw competitive districts. And here you're going to need to figure out, what does a competitive district mean? What threshold is that? So you're going to need to use some level of political data, whether that's, usually it tends to be election results. So consider what election results and how far back you're going to go, and figure out how competitive they need to be in order to satisfy this criteria. And finally, proportionality, and this is a new one, brand new, hasn't been used in redistricting yet. It's something Ohio will be doing for the first time in 2020. And the idea is to have, when you look at statewide, to have a statewide proportion of districts whose voters favor each political party corresponding to the statewide preference of voters. So you're trying to keep sort of party preference in line with the number of seats. And again, they're going to have to use political data to do this. And Ohio has decided to use statewide election results for the past 10 years to determine proportionality. So just a quick note on what I call other quote-unquote principles. These aren't really the things that you necessarily think about when you talk about principles, but they're things that might be important when you're putting together a list of things to do. And the first is nesting, and that means each House or Assembly district or several House or Assembly districts are entirely within the bounds of a Senate district. In Minnesota, that means each Senate district is divided into 2 House districts. Some states require this, and some states recommend but don't require. Numbering, do you have any particular numbering scheme that you need to follow? You know, start in the northeast corner and go north to south, west to east, whatever that might be. And then it's important to think about whether you have single or multi-member districts. So Senator Rosenberg did a good job summarizing to say, this is a balancing act. So as you're talking about these and thinking about them, at first they all sort of sound simple when you think about the definitions. But as you start to layer them together, things overlap, they bump into each other, and sometimes they just outright conflict. So how can you draw a compact district if you're trying to preserve a political subdivision that's sort of oddly shaped and sprawling? How do you preserve the core of a district while also preserving a community of interest that's sort of sprawling over more than one district? And some you just can't really square together. So how could you do a competitive district requirement while also prohibiting use of political data? Those just aren't going to work well together. So what do? The federal requirements that Senator talked about always come first. Everybody complies with those. Start there. And then come your state principles. So as the Senator mentioned, you're really going to end up oftentimes balancing these. It might not be possible to comply with all of them all of the time. So you're going to have to sort of piece together a reasonable approach that will stand up in court. And you're going to hear from Peter later today talking about how do you come up with a plan that will withstand scrutiny. So there are a couple of things to think about as you do this. You know, you might want to include a phrase for some of these, you know, where possible. We talked about that with competitiveness. It's not always possible, so that gives you a little wiggle room. You're going to need to consider trade-offs. Maybe include some of your criteria as subordinate criteria, and we've talked about that as well. If there are a couple that you think just you'd like to do but maybe aren't as important, label them as subordinate, and that will help sort of in the balancing act. And then finally, some states take that a step further and they actually prioritize their criteria. What this means is essentially they list their criteria in priority order and start at the top and work their way down. They might be able to comply with all of the criteria, but if they can't, there's guidance on where to focus. And this really helps take out some of the guesswork for the map drawers, and it might help minimize some of the challenges of, you know, picking one criteria over the other. So before we get to questions, I just want to say, I'm sure Wendy will talk to you about this later today, but it's worth hearing a whole bunch of times. NCSL has the Redistricting Law 2020. It's the red book. If you don't already have a copy, get in touch with Wendy and Ben and they can get you one. It's fantastic. And all of the redistricting staff at NCSL are really awesome. Send them your questions and I'm sure they'll all be happy to help you. So with that, I think we have plenty of time for questions for the three of us.
Thank you, Lexi. That was just fabulous. I really appreciate what you had to say. And I was picking up on the word you used about conflict between the criteria. And conflict, of course, is what we see when states don't follow law and they end up in court. So anything that can be done to reduce conflict seems like a good idea. And you've given some ideas on how to do it with the criteria, and Senator Rosenberg gave some ideas about how to do it in terms of staying out of court. So all good. I was thinking that possibly people in New York are a little confused by the idea of states that do not use any kind of political data. I think that in Iowa they don't even use the residence of incumbents. Do you know more about that? And have you got any thoughts from the Minnesota perspective on how states can operate without any political data at all in this essentially a political action of redistricting?
I think that one's for me, Wendy, so I'll take a stab at it. Yes. I think that's an interesting question, and I don't have a perspective on that. We don't have anything real specific in Minnesota on whether you can or can't. We have looked at incumbent protection before, so we need that level of data. You're right. I think Iowa is prohibited from looking at all of this data when they are drawing their maps, but they are also relatively unique in that they have nonpartisan staff draw their maps. So I think part of it might just sort of be how you're setting up your redistricting and who has access to that data. I think it's also important to think about, you need to make this choice early in the process and make everybody aware of it. So you can't make this decision once the data is already out there and everybody's looked at it. So I think this is a very proactive issue. I don't have a lot of practical thoughts on how that actually works in a state, though.
Then I'll just say to New York that if they need anything further on that, we'll be able to connect them with people in Iowa. I have another question for you too, Lexi, and that is that I know in Minnesota you use the courts for some of your redistricting. Could you just give us the thumbnail sketch of what happens if the legislature can't get the job done?
Sure, happy to. So essentially we have a statutory deadline in Minnesota that comes, early February in a year ending in 2. And in the recent cycle, the legislature hasn't either been able to adopt a plan through both bodies and send to the governor, or the governor has vetoed the plan. So that means we're bumping up against the time to live in a district, file for election, all those sorts of things. And that's when the courts will step in. We had a special panel appointed that ended up adopting their own redistricting principles and then drawing the maps for us. And the courts have drawn the maps in Minnesota for the past several decades. So they just sort of step in at the last minute and take over when the legislature wasn't able to meet the deadline.
Got it. We think of either legislatures doing it or commissions doing it, but in fact there's a third body that can do it, which is the courts. Lexi, would you be willing to put your email address into the chat box in case anybody wants to talk to you after the fact?
Yes, I'm happy to do that. It's also on the first slide. I should have pointed that out, but I will put it in the chat box once I figure out where the chat box is.
Okay, sounds good. And the slides will be available. They are up there in the tabs above the slides, so they can be downloaded either by individual speaker or as the whole unit altogether, so people can re-access those. So thank you, Lexi.